Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
If John was beaten up and attacked in that house, who did it?
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record.
All right. How is everybody? Oh, my Lord. That's better. Everything is all out of whack. Now I feel better. I feel in whack. Wanted to talk with you guys. Hey, Shelly. Hey, my King of Kings. Kimmy K. Lazy Susan. Hi, Tammie. Pats to Gizzy. About the Karen Reed hearing, which was hours and hours of Robert Alessi's word salad. Thought we'd start with that. What is word salad and why is it used? I mean, we had hours of his talk. This is the same tech talking in circles, shifting blame to the Commonwealth, shifting blame to the judge at the end, that how dare the judge use such hyperbole to say that there's going to be grave consequences for the defense. I don't think she liked that one bit. Hi, Busty DD, my King of Kings, Manny. Nice to see everybody. So let's go over what word salad is before we delve in. I'm going to spare you Robert Alessi, but it's a technique where they bring up your supposed wrongdoings and they ignore all. So he basically ignored the point. The point was that they lied. So if you're missed out, the defense lied to the court as recently as after they lied to the media, but they as recently as their February 16th filing concerning their ARCA witnesses. So they have been saying up to the 16th of February and afterwards to the media, but to the court, to the judge, to the jury, they presented their ARCA witnesses this way, that they were wholly unpaid, independent, unbiased witnesses, and that the Commonwealth could have used them too. And when they were asked for the discovery, they said in the first trial, we can't give you the discovery, Your Honor. We can't. We're not allowed to talk to them because there's a federal investigation going. Now, I thought this was apparently big news this past week that the federal investigation is over. I thought we all knew that it was over months ago, but apparently we have the confirmation. Came up in another trial in Massachusetts, who wants to use the same Karen Reed technique of blame the police. That was announced in that trial that the federal investigation is over. Now, Karen Reed and Aiden Turtleboy Carney are saying, you can't believe the lying press. You can't believe, I guess, the lying judge in another case. They just repeat what they read. And the feds are beholden to Karen Reed and her innocence fraud campaign. So they're not going to come out and announce it's over. but they basically confirmed it's over with the press. They're not going to publicly come out. So Karen Read needs this innocence fraud campaign to continue. You go back to word salad. This is Alessi's technique. He talked in circles. He used a condescending and patronizing tone for certain. I'm going from the 10 warning signs of word salad. The link is in the description of this video. They accuse you of doing things that they themselves are doing. So we saw that when they wanted the ARCA discovery, they said, but the Commonwealth hasn't handed over the discovery, when it sounds like Hank Brennan has been vigilant about handing over every piece of discovery that he can. They use multiple personas. So they play both sides, and they play the eternal victim. And they give a lot of excuses. So it basically is a technique. It reminded me a little bit of sitting in court at the NXIVM trial and listening to, in those early hearings, some of the, and also their sentencing hearings for sure, and listening to their circular, it's kind of like a gobbledygook. So each sentence kind of eats its own until you feel like your head's spinning by the end of it. I find it exhausting, and I didn't find it particularly effective. Now, if you are, hey, B. Tim, what do you think of the photo showing ARCA witnesses with Yannetti and talking to Bill Reed's dad? I don't know exactly which photo you're talking about, Tim. But they were in communication as early as May. ARCA was keeping accounting of their time, which is really key. But according to, I'm just really shocked to see Andrea Burkett. I'm not shocked to see. I'm shocked to see them doubling down and defending these lawyers as they always do. So even as, you would think that if you're a lawyer, right, you would want the bad actors out of your profession. Not so much these YouTube innocence fraud lawyers like Defense Diaries. I guess he's more of a podcaster, Defense Diaries, and Andrea Burkhart, because they're doubling down and saying that it was a master class. Alessi's word salad. It's been called filibustering, which means that he was talking for so long that he was leaving little time for Hank Brennan to talk. So by the time he finished talking, he had sucked all the oxygen out of the room. Absolutely ridiculous. And it's the same technique he used with Marie Russell. That voir dire was ridiculously long-winded. But here's Defense Diary saying, after the lunch break, Alessi did yeoman's work and got to the heart of the matter. When? Defense Diaries? Let me share my screen so you know what I'm talking about. This was so absurd. You got to see this. You got to see it. I can't believe this stuff I'm looking at. Did yeoman's work and got to the heart of the matter. Alessi did. He got to the heart of the matter when? He has been brilliant. I don't think so. And I no longer believe that Alan Jackson is in peril of being removed. He's just playing to the Free Karen readers, getting their hopes up. I think Jackson is on his way out, but you never know with this Judge Cannoni. She's very defense friendly. The 10 misstatements by Hank Brennan as laid out by Alessi. See? Blame shifting. It's Hank Brennan who corrected his misstatement. He thought that the materials were given to him by the feds, and he said so in court. When he found out otherwise, he corrected it by the end of the hearing, not months and months later, after demanding discovery. And let me remind you that that Lally went through the same thing that Hank Brennan did, demanding discovery, and then they got a voir dire hearing, and you'll hear Hank Brennan talk about the pointlessness of voir dire hearings. I don't know what to ask. I don't have the materials. The 10 misstatements by Hank Brennan, this is Defense Diaries again, as laid out by Alessi, were devastating. Oh, they were devastating. Oh, so devastating. The question is now, will Judge Cannoni reprimand Hank Brennan? For what? For what? So just move it forward. So I think what you can gather from this is that all these lawyers are doing it too. That's my interpretation. Why would these lawyers cover for Alan Jackson and David Unetti's fraud upon the court? Wouldn't they want these kind of lawyers out of their profession, their fine profession? But let's get into it without further ado. Here is the hearing from Friday. I'm going to start with where Judge Cannoni, I'm going to spare you Alessi's mind-numbing gobbledygook, hours of it, because I don't think any of us could take listening to that again. But I will play where Judge Cannoni asks all the lawyers at Karen Reed's defense table, who were strangely silent, Alan Jackson, David Unetti, Elizabeth Little, if Alessi was accurate and spoke for them. Let's take we're back.
Questions, and I may have questions for both sides next week, but actually what I want to do, and you said I could ask questions of other counsel. So while memories are fresh, I just want to assure the accuracy of what was just said. So I'm certainly not going to order counsel to answer my questions. You don't have to, but I am curious. So we're going to start with you, Mr. Unetti. As an officer of the court, is there anything that you dispute that you just heard from Mr. Alessi? And what I'm particularly concerned about is what you knew or what you didn't know and when.
No, what he said was entirely accurate.
Okay. Mr. Jackson, same questions.
No, and I would simply elucidate with regard to the February 6th sidebar comment. As I look back at I didn't remember making the comment one way or the other.
So this is a comment that we weren't privy to, but he seems to have picked up that the judge is particularly upset that he lied to her face. So I can go over the lie if you guys want to, but it's in their February 16th filing. They were totally unpaid witnesses when we know that they were paid. But here Jackson picks up that Cannoni's particularly upset that he lied right to her face in sidebar.
I didn't remember that sidebar.
I did.
Well, I'm sure the court did after it looked at the transcript.
No.
I
did long before I looked at that transcript.
Right. The context of that, what was in my brain when I said we don't have anything else to give, which when I reviewed the transcript, was very clearly the federal batch of information, what we referred to as the federal dump. I did not have in my head at all emails, communications, things of that nature. The
invoices, payment.
No, nothing. Because the context of what Mr. Brennan was talking about being frustrated about were his TUI requests concerning the federal batch of information. And that's when I was making the additional statement. We don't have anything that they don't have concerning the federal information and the background information for the.
We don't have anything that they don't have. Please don't make us hand it over. Oh, once they hand it over, and they haven't fully handed over everything. This is just a tiny, tiny bit. Can you, I have a feeling that the things that they're still not handing over are just as damning. But it goes all the way back to May. They're in communication. And the Free Karen readers are saying, well, this was unsolicited. Like they just handed the bill, the defense a bill, and the defense decided to pay it. They called it totally unsolicited. Like I made this analogy before, but you know, when I don't ask for my restaurant bill, I'm not, you know, and they just put it down. Doesn't mean it's a surprise. Doesn't mean I don't have to, that I'm not expecting, the restaurant's not expecting to be paid. I mean, come on.
The ARCA experts. That was it.
Your Honor, if I could, this is.
No, hold on. Ms. Little, it was just thrown on you that you're responsible for all discovery, but the same question for you. And again, you don't have to answer, but is there anything that you dispute in the accuracy of what Mr. Alessi told me about what you knew and what you didn't know and when?
No, Your Honor, I would just add that as soon as the court issued the order, I obviously was not in court that day, but as soon as the court issued the order that ARCA reciprocal discovery be provided, I gathered those documents and I provided it. So that was the, I guess, prompt for going to look to see if we could satisfy the 10 things that were outlined by Mr. Brennan.
Okay.
So I'm curious what those 10 things are. Does anyone know what those 10 things are that are outlined by Brennan that he wanted in particular? Do we see any of them? Do I need to go back to his filing? I guess I do.
Okay, so I'm going to hear from the Commonwealth now. It does not look like we'll finish this today because we'll be ending around 4 o'clock, but I will.
So if you know anything about the law, so what the judge is doing here, in my view, is taking out the defense that Alessi didn't know, because one of Alessi's techniques was to say that the right hand didn't know what the left hand was doing. Yannetti didn't know that Alan Jackson was talking to ARCA when they were communicating. And when they were communicating, it was only, this is Alessi's points, not mine. I mean, that they're all, and as Hank Brennan points out, they're all a team. And he says, when I leave one person off an email, they all remind me that I have to tag in the other person. So unlikely that they don't know. They all know that this was a lie. And Elizabeth Little, trying to save herself there, is saying, well, I'm the one who handed it over. And I tried to. It sounded like she poorly complied because we still don't have a complete record of all the communication with ARCA. Let me just pull this out for a second. Just wanted to share excellent tweet by Julie Carpenter. Robert Alessi dances around the truth. Defense motion betrays him. The motions hearing in the Reed case, which abruptly ended last week when it was learned that the defense had not only previously undisclosed communication with the ARCA experts, but also that the defense had paid them, continued today with defense newcomer. This is Karen Reed's new pro bono lawyer. This is me speaking, not the author. Robert Alessi, aggressively long-winded effort to save his co-counsel from adverse action. Alessi argued rather incredulously that not only did Yannetti and Jackson not make false statements to the court because they were thinking of other things, Jackson, or didn't know what each other had done, Yannetti, but that it was actually Hank Brennan's fault for misleading the court as to the source of the information and the judge's fault for misinterpreting the material. Last week, Brennan had initially misspoken and stated that the materials that came from, I'm just skipping forward, between Jackson and Dr. Wolf, he thought they had come from the feds, but they came from the defense. Alessi, after finishing his long argument, Judge Cannoni gave David Yannetti, Alan Jackson, and Elizabeth Little a chance to correct anything they disagreed with in Alessi's remark. All three confirmed Alessi's statement as fact, and this was the exact moment when the defense team sealed their own fate. On February 16th, the defense filed their response to the Commonwealth's motion to exclude ARCA. In the motion, the defense again made the blatantly false statement that the defense had not paid ARCA. The motion was signed by every member of the defense team, including Mr. Alessi. So here it says, ARCA expert witnesses who were not hired or paid for by the defense is not made in good faith. So they're accusing the Commonwealth of not acting in good faith, which is lawyer talk for basically trying to dupe the court while they're trying to dupe the court. So once again, blame shifting and pointing fingers to the other side for doing exactly what they're doing. In a desperate attempt, I read this last time, and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the judge in this case. So that will give you an idea. So here, Judge Cannoni is sealing in her fate. I believe if Jackson is thrown off this case, Elizabeth Little will, and possibly Yannetti, for he gave them their pro hoc vice status, which means that they can practice. They're practicing under his bar license in Massachusetts, and it could be revoked by the judge. Also, ARCA could not be allowed to testify. And it could go further with bar actions. And the problem with bar actions is that it's lawyers deciding your fate. And we've seen this week, I've read out a few, lawyers, instead of calling out these frauds upon the court and saying, we want a dirty player off our team, say, oh no, they misunderstood. Maybe Jackson didn't know in California that he didn't have to disclose what they were paid to the Commonwealth. Of course he knew, he had to know, and he was lying all along, in my view. Let's get back to it.
Mr. Brennan.
Attorney Alessi ended his argument talking about the Sixth Amendment and discounting repeated or repetitive violations. When you consider the conduct in this case, you should consider the history of the case, including repetitive violations, 3.6 violations, protective order violations, and then discovery violations, representation violations. The defense in the first trial attempted and successfully did portray ARCA witnesses as wholly independent, presented themselves as oblivious to the nuances of ARCA, left the impression that there was no compensation, no bias, no collaboration. They posture the information that they gave in advance of the second trial, and I'm going to get to the timing of that, but it ignores entirely withholding this information before the first trial. The defendant presumed innocent has a right to a fair trial, and so do the people of the Commonwealth. It is clear from a reading of the transcripts and the records and the posturing of materials that there was information that showed that ARCA was not wholly independent. Information that was known to the defense, and for whatever reason, perhaps a strategic advantage was not provided to the Commonwealth, the court, nor the jury. Mr. Attorney Alessi talks about the Gonzalez case. In that case, there was one attorney to cross-examine a witness, which is protocol. Another attorney passed a note, a minor violation of a court procedure. That is like a raindrop in a hurricane. We have a code of ethics and rules to ensure a fair trial for everybody, both sides. Coming in at the last hour.
Right. This is about basic fairness to both sides. If the prosecution had done, Commonwealth had done something like this to the defense, they would never stop screaming about it. And in fact, they're still screaming about, they just put in a motion to dismiss about how Karen Reed should not go to trial, dismiss all the charges against her because of the mirrored Sallyport video. But had they withheld the Sallyport video or withheld something else and used it the way they used the ARCA witnesses, it was their best witnesses, because for that reason, they know it's the best thing they have, because they could say that they were unbiased, that they were hired by the feds. We know that the federal investigation was started by Yannetti and Karen Reed, but never mind that, to make it look, just make it look like, and that's how innocence fraud is done, to make it look like something improper is going on. Doesn't have to be and make that is what fraud is all about. Make something look like something it's not. I love his language here though. Raindrop in a hurricane. So true.
And provide information when the avalanches started is not enough. This isn't just about Rule 14. My effort with the ARCA witnesses from the beginning, and I've been clear and consistent, is not to preclude them. It is to get fair discovery that we're entitled to. I did not know before a few weeks ago what the defense had known. I did not know that there was conversations and efforts made between them and then inevitably compensation paid. I didn't know that, but I certainly suspected it. I saw Your Honor's questions before voir dire, during voir dire, after voir dire. I remember the conversations sidebar. And those questions were right to the point. And when we were sidebar, I specifically mentioned, I don't know, a voir dire is inconsequential. I don't know what to ask. I can't send them back home to get their records or their emails or any.
Right. This is Robert Alessi's point. And do I have to call him Alessi now? I don't care. As long as I get John O'Keefe's name correctly. Is it Alessi or Alessi? I really don't care too much, frankly. He's such a horrible, what an ambitious ghoul. I mean, Yannetti, Alan Jackson, their behavior is horrible, but it's their job. Alessi's jumped on this pro bono because he wanted to be part of the fraud. What a disgusting human being he is. And he has to sit there every day with Peggy O'Keefe with her handkerchief in her hand, wiping her eyes, looking at her in court every day as he puts up these, in my opinion, fraudulent arguments, with her weeping and feels nothing, trying to get her son's killer off. What a disgusting human being.
Billing, all of that was denounced. All of that was portrayed as baseless. But the court had questions. I had many of the same questions. It is not a surprise that we start to scratch off the tip of the iceberg. It is not complete. There is a murky relationship between the defense and the United States Attorney's Office relative to these ARCA witnesses. And there is a very unclear relationship as we stand here right now between the history of interaction between the defense and these ARCA witnesses. You can see from the emails, while there is some information provided, there are gaps. There are enormous gaps in time the pause moment on March 24th and then reinitiating on May 5th, where ARCA is actually billing the defense for their works before the voir dire. There had to have been communication between that time that rekindled this relationship. There are 2 requests that are mentioned in the emails. We didn't get all of those responses. And so we do not have an affidavit from either counsel or any of the counsels. We did not hear a word from any of them. According to Mr. Alessi, what you should do, what the court should do, is go to the federal government and ask.
So
questions.
just to be clear, I am not having ex-parte communications with anyone about this case. So I am totally rejecting your request that I do that, Mr. Alessi.
This is really interesting right here. So Alessi said at the end of his speech, before you punish my client, this is what I got from it. So I am not quoting verbatim. If he meant something else, please forgive me, but this is what I got. Before you punish my client, talk to them. Basically, have them pull the wool over your eyes. Before you give them any punishment, just talk to them. And the judge responded very negatively. That seemed to put her in an even worse mood. Because let's not forget that her fraud, by letting this all happen in this court, has been called out. So by letting it happen, you're making it happen. This was 3 witnesses we had voir dired. And I'd like to make a correction. So I played a clip of Yannetti discussing 3 witnesses that they were going to call. I thought they were talking about Marie Russell and the 2 ARCA witnesses. And there was confusion in court over this. It was unclear, even amongst the lawyers and the judge, who they were talking about. But they were talking at the time about the ARCA witnesses. There was 3 ARCA witnesses. Another one, Mr. Klein, Scott Klein, and we'll discuss him in a second, but I just want to make that clear. It was not Marie Russell. But for 3 witnesses in this case, discovery was not handed over, and instead they had voir dires, which, as Hank Brennan points out, it's totally useless. If you don't have the material, if you don't know the questions to ask, defense knows that they're at an advantage. They don't know what to ask. They can't ask it. They don't have all the information, which they weren't given. So Alessi's part of his argument, besides that you should talk to my clients, I guess he was representing them, or talk to my fellow lawyers before you put down a ruling on this, or a punishment, sanction, etc., is that she had already remedied the situation of discovery by having nothing was lost because they had these voir dires. They already were punished. They had these voir dires in placement. I mean, all it reminds me of is born and raised in a briar patch, like not the voir dire for a lawyer, for the defense team. What a punishment. We still don't have to hand over any information to the Commonwealth, and we get to ask whatever inconsequential questions we want at the voir dire.
It wasn't a request, Your Honor.
You suggested that I call them.
No, I said if Your Honor wanted to.
If Your Honor wanted to, that's not a request? That's not a suggestion? Then what is it, Alessi? If that's not a suggestion, what is it? You explain. I'd love to hear him explain how that's not a suggestion. Please. But probably would take 4 or 5 hours for him to explain how that's not a suggestion.
I didn't suggest that, Your Honor.
I'll move on, but the point is, it is not.
He brought it up as a possible thing for her to do. Is that not a suggestion?
Incumbent on the court to provide the proof that the defense was given the opportunity to bring in today to clarify the record. Instead, it is the typical 101, blame everybody but themselves. There's no acknowledgement. There's no contrition. And there's no confidence that we are going to get all the materials that we're entitled to. To suggest that Archer's position did not change, it did change. Their opinions did change by the time they reached trial. It is not that the defense brought out that there was an expert in lighting or crashes happen at night. It is the bias, the relationship that is critical. And that was hidden from the court, the Commonwealth, and the jury. It is the bias and the leaning towards one side that was not disclosed. It doesn't help the first trial to disclose it last week or 10 days ago. So let me offer a quick history. It is true, when I first spoke to the court, I believed the documents provided by the federal government, and I did correct that record as soon as I learned before court ended for the day. January 30th, 2025, the United States Attorney's Office responded to one of my TUI requests. They provided billing, including ARCA billing. There was billing for their reconstruction, but there was no billing provided for their preparation, voir dire preparation, travel expenses, trial testimony. That information was provided to both sides on January 30th, 2025.
There you go.
It seemed at that point that the federal government was being at least a little more responsive, although not directly. No bills other than what the ARCA experts did in putting together their demonstration and their accident reconstruction. February 11th, I filed on behalf of the Commonwealth our motion to exclude the ARCA witnesses. On February 12th, the United States Attorney.
I mean, you see by a $23,925 bill that they're making some more than some people make in a year. And your flight, your snacks, your hotel, all paid for you. Nice work if you can get it, being an expert witness.
His office, it gives us new emails. And those emails were between the defense and the United States Attorney's Office regarding their request to use ARCA witnesses at trial. It's not a surprise that on February 13th, on the heels of these more productive disclosures by the federal government, we then received the disclosures from the defense, which are the emails regarding conversations between Attorney Jackson and Dr. Wolf, and the invoice for billing. Now, I did misspeak, I corrected it, but it is not the source of that information. It is the substance.
Right. It's not the source that's important. Who cares whether I got this from the feds or the defense? And he said, I love how he's saying in the beginning, it basically, I had to create a avalanche or whatever natural disaster he used to describe it, to get this information. That is not, I had to kick and scream to get this information. When it's finally handed over, you're saying I misspoke. I thought I got it from the feds. I got it from the defense. I corrected myself by the end of court. Not so the defense. They let this lie go on until after last hearing. Alan Jackson was still lying to Christina Rex, saying, of course we didn't pay them. Do I need to play the tape again? This stuff makes me so angry. Why can't they just play by the rules? If they're such brilliant lawyers, if this is such a dream team of lawyers, why can't they just play by the rules? Why do they have to go beyond the rules? Why do they have to play dirty if they're so brilliant? If these are such brilliant lawyers.
Of that information, what is critical and relevant. It is that information that should have been known to the court, the Commonwealth, and the jury at the first trial. And it is also that information, when you compare it to the representations that have been made prior to trial by the defense, that has import. Before, and I'm not going to belabor this and go through the comments, most of them again, but it is important before I get to the representations. The court does consider pro hoc vice. We have one licensed attorney in Massachusetts who's carrying 3 pro hoc vice attorneys with the request for a 4th.
Yeah, let us not forget that they're asking Betterow to come on that same license. Elizabeth Little is on Yanetti's license, Alan Jackson, and Alessi. So if Betterow comes on, that will make 4 lawyers. Right? Is that right? Betterow, Alessi, Elizabeth Little, Alan Jackson. Yep, 4. 4 lawyers all on his license. And here, this is the disappointing part. I don't know why, as Yannetti is being uncovered to being part of a fraud upon the court, that why Hank Brennan has to compliment him. And this shows again, these lawyers are part of the problem. There is no independent auditor, not made up of lawyers. Or let's say we have these things that the wrongful conviction movement put all through. It's like a get out of jail free card, a conviction integrity unit. And they're made up of all kinds of people. Not so here. The only ones that are policing lawyers are other lawyers. And this is a problem. And as our justice system is being corrupted daily by these fraudulent lawyers, we have other lawyers protecting them. Manny asks, how is the free Karen Reed and Karen Reed spinning this? Well, first they lied. Alan Jackson pretended he didn't know what was going on. He didn't know what it was about, when I understood it, and 80% of my audience understood what was going on at the moment it happened, and Hank Brennan explained it and brought the receipts. They're blaming Hank Brennan for misspeaking. They're claiming that at the time that they testified, they hadn't been paid. So that's the same thing as presenting to the court that they will never be paid. That the jury should have known that just because they hadn't been paid, that they said they hadn't been paid, that isn't the same thing as they saying they weren't being paid. So semantics. How else? They're saying that Hank Brennan is making a mouse out of a molehill because he wants to obscure Karen Reed's powerful motion to dismiss the whole entire case. They're saying that. And otherwise, they're staying silent. That's how they're doing it. Funny Bunny. Daniel Wolf, who's the ARCA expert, addresses AJ as Alan, not Mr. Jackson. Tells me they've spoken more than once. Good catch, Funny Bunny. We will never know. Right, in the emails, he says Alan. Sure, we haven't gotten all the discovery, Funny Bunny. We haven't. We've gotten a tiny portion, as Hank Brennan points out. So I see people putting together timelines of the ARCA. I'll show it in a second, but it's really incomplete because we don't know the full communications. We can't know what we're not given or told.
Ride on that same license. There was a responsibility, respectfully, to Attorney Yannetti. He's a fine attorney, an excellent attorney who I admire. But there is a responsibility so that there are not a number of pro hoc vice lawyers doing different things and then later plausible deniability. when we send emails, if I should miss one person on an email, I will receive an email telling me that make sure everybody gets every communication. I've been corrected or redirected many times when we've left somebody out on a communication. Pleadings are signed by all parties. They come through the bar card on that table. And so to try to parse or mince or put a slight on words to suggest that things are done independently and there's no responsibility for the defense when a representation is made that's inaccurate isn't enough. It doesn't assure that in the future it won't continue. Now,
Right. You take on that responsibility of when you have someone using your license, you make sure that everything's above board. But we also know from the clip I played last time where Yannetti says, I can't talk to them. I'm not allowed to talk to them when they were talking. We never talked to them before when they were talking. We only got their qualifications and for the purposes of testifying. We can't talk to them because there's a federal investigation going.
Mr. Alessi said there were rules of the road. This was before his time and mine, but I've read the discovery. There were no rules of the road. There was a protective order. And the protective order was clear that there was no discussion outside of court about the federal materials. And there was nothing in the protective order or direction from the U.S. Attorney's Office that the Commonwealth had any right or privilege to contact any witnesses. Everything is done by the book, by regulation, through TUI requests.
So I have to say, I've never seen the protective order. I received a stack of discovery that the federal authorities were kind enough to get to me in advance of trial last time because Mr. Jackson had told me he understood that I was operating from a place that I didn't have enough knowledge essentially of what was going on. So I received those 3,000 pages plus. I did not receive a protective order. I don't know that I'm entitled to it, but it would be helpful. I don't want to take it if I'm not entitled to it. I don't know what the parameters are.
Your Honor, we have a copy of the protective order. I did ask co-counsel if there was any limitations to it, and I don't have a certain answer. What I'd like to do is
Call over there, please. All right. If I can have it, I'd like it. It would help guide me through this. If I can't have it, I'll just go with everything I've heard.
May I have a moment to speak to counsel?
Sure.
It's curious that here.
What a difference this makes.
Here's me talking, but I think I cut this part out. But it's curious that the judge doesn't have it and that Alan Jackson isn't getting up and it's Yannetti, because you would think that Alan Jackson would want to deal with that, not Yannetti.
any witnesses directly because they understood that that was precluded. And so there was not an opportunity to call or discuss or have conversations, share direct examinations, or have emails with these witnesses. In fact, it's underscored, isn't it, by the emails that we received where Dr. Wolf replies on the 24th saying U.S. Attorney's Office essentially told them to hold off on communications. It doesn't seem like that would be a very clear rule of the road to have independent conversation with these witnesses and then be cautioned that that no longer was viable. And so inevitably, it was the understanding that nobody would be speaking to the witnesses. And I did see in the transcript, in the voir dire, where it was asked, were you available to the Commonwealth? And the witness said yes. I don't know any basis whatsoever for the witness to suggest that there was any invitation to speak to them. And so what we have is we have witnesses that were.
Right, that's a great point. So they made a big deal about in court, like the Commonwealth could have called you up and spoken with you and even hired you. Here is just on Alessi, before I forget. I'm not exactly sure how to pronounce his name. I'm sure I'm so terrible with names. I'm sure I'm going to mispronounce it. But Matthew Panknick. He's a lawyer. Here's what he had to say about Alessi. Take a listen.
In panic law. Wow. What are
To panic. My apologies. I am something with names. Let me see. It's up all the way.
we watching? I really can't really tell you. Attorney Alessi is being asked questions pretty clear by the judge. He's not answering them. He's just, I'll get to that in a moment, and then never seems to get there. I think we're at roughly 90 minutes, I would say, with breaks and everything, of him just essentially filibustering. I don't know how much the judge asked, how much longer he said 45 minutes or so.
I'll say what I said then, which it would be better if he just stood up in front of the court and said, "You caught us dead to rights. We're sorry." I think that would have been more effective than what he did. He blames the judge for her wording, for being upset and saying it may have grave consequences on the defense. How dare she be offended by the fraud upon the court that the defense did?
So I don't know if he's going to come to a point, but he did admit that the ARCA witnesses were paid by the defense. Kept saying it came out of the blue, and it's like, why would it didn't make sense why it would come out of the blue when you sent a retainer agreement, they testified, and then you guys are surprised when they bill you for it. It just doesn't seem cohesive. So I don't know how much Special ADA Brennan is going to have to do to respond. It feels like Judge Cannoni has already made up her mind, and I think she did before the hearing. So we'll see what happens, but I don't know, based on the fact that Attorney Jackson seems to be...
Right. You just get a bill out of the blue. Which is, at least in New York, there are laws for that. Even on ice cream trucks in New York, you have to know how much you're being charged, you have to have certain arrangements you have certain rights as a consumer. You don't just get bills out of the blue when you think something's free. It's not how life works. I mean, the free Karen readers are in la la land with this. Because ARCA is the best thing Karen Reed had to her defense. We all knew that she started and Yannetti started. All of Karen Reed's defense comes out of her brain and not fact, or most of it, or exaggerating on small details and pointing elsewhere. She doesn't really have a defense. So this was really the best thing. It was created by her, this investigation. And these very biased witnesses looked at a fraction of the evidence with questionable tactics, i.e. building a cannon. Never looked at his car and came to a conclusion.
He being almost thrown to the wolves, if it were. It seems like Attorney Lassie's trying to insulate Attorney Yannetti, basically saying he had no knowledge of the email and this, that, and the other. So to almost preserve the defense, because if Attorney Jackson is removed, which is possible, Judge Cannoni could also lay the blame also at Attorney Yannetti's feet, because he's the sponsor.
He's the sponsor, but he also lied to the court. What he's leaving out here is he also lied about this before a voir dire was offered as a remedy. Yeah, I can go back and play that. But I think Jackson's going to get the brunt of it, but maybe Yannetti also. He was part of it. They were all a part of it. Elizabeth Little, and if Alan Jackson leaves, Elizabeth Little will leave, and possibly Yannetti. That's what we're looking at here. And ARCA may not testify. I think it should go much beyond that. I think they should be reported to the Massachusetts bar and the California bar for this. lawyers are expected to act within the law.
Sponsoring attorney in a pro hoc JV situation. So we'll see what's going to happen. I don't know if we're going to get much more in the next 45 minutes in any kind of substance, but I definitely feel.
So he's saying no substance. No substance. Just filibustering, which is like when you read a recipe book and run out the clock when you're arguing a law.
Like it's not going to end well for the defense. It may not happen today, but I don't know if Judge Cannoni is really buying what Attorney Alessi has to say.
So, Attorney Alessi, we've had 3 pronunciations of his name, but that'll give you just a little idea how more normal lawyer acted. But shall I remind you of Alan Jackson in court? I think this is a good time to show a reminder of what we're talking about here. Here's Alan Jackson in court doing the direct examination of Daniel Wolf, the ARCA expert.
You were not hired by the defense in this case, correct?
That is correct.
At the time you did your expert review, Dr. Wolf, and your consultation, you and I had never met.
That's correct.
You did not know who I was.
I did not.
You'd never met Ms. Little.
No.
Mr. Unetti.
No.
Matter of fact, you'd never heard of this case.
That's correct.
You were hired.
At the time he did his examination, he was working for. So these are the findings of his examination, which changed substantially, but it's so absurd.
Hired by another agency not connected in any way to the defense. Is that right?
Correct.
And not connected in any way to the Commonwealth. Is that right?
Correct.
So your analysis and your conclusions and your opinions are completely independent of the defense and the Commonwealth in this case. Is that right?
Objection.
So unfortunately that was sustained, but that's how he presented ARCA, totally independent from the defense and the Commonwealth.
Sustained. Mr. Jackson, you can ask it differently.
When you did your analysis and conclusions, well, let me ask it this way. You finalized your report, you and your team, correct?
Correct.
That report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right?
Correct.
The defense didn't have anything to do with that, correct?
Correct.
You had never met us, didn't know who we were when you did this.
Correct.
You'd never met Mr. Lally, didn't know who he was when you did this.
Correct.
So your analysis, opinions, testing, and conclusions were requested by a completely separate agency.
That is correct.
All right. Goes without saying, but I'm gonna ask it anyway. You haven't been paid by the defense?
You have not paid us anything, no.
You were not.
Okay, so not paid for it by the defense. That's the key part right there. Not paid for that, and he kept up that lie. Here's an ARCA timeline. But we're just going on a little bit of what we know. So this is just on the skeleton documents that we've been given. So an email between Jackson and Wolf on the 22nd of March, 2024. Then there was the Rule 14 hearing violation and voir dire on the 10th of June. After that, there's another email between Jackson and Wolf on the 22nd, 23rd. Then there's his testimony on the 24th of June, 2024. Then the invoice came July 12th, 2024. Invoice was paid July 26th. TUI letter number 2, December 4th. The 1st of January of this year, notice of intention to exclude ARCA. There's the email from USA, 6th of February, email from USA, motion, email production came from the 13th to the 16th. So that'll give you an idea a little bit of what we're talking about here when we talk about ARCA.
Wholly portrayed as independent. When we look at the testimony, it was represented many times in court, leaving the impression that the defense had no access and no special relationship with the ARCA witnesses. On June 5th, 2024, day 26 of trial.
What date?
Day 26.
No, I know that, but what date?
June 5th, 2024. Discussing scheduling and voir dire hearings. The defense said, I provided everything we have. I can't make up discovery. I mean, I got a report. And everybody in this group knows why I can't provide additional discovery for ARCA. Everybody knows they've got what I've got. Your Honor asked.
So this is the sidebar. I assume they're talking about. Everybody knows I can't make it up. We can't give over what we have. It's not that we're trying to sandbag the prosecution. We just can't make up bills that we're hiding. That's what they're saying. We're hiding everything, Your Honor. We can't make it up.
I haven't. If you can't, that's fine. So not everybody knows, and I make those decisions. Response, certainly. You're the one who needs to know, and I thought you knew. The federal authorities will not allow me to interview or ask for additional information from anybody in their world. So I have nothing. I've got a report. He's got the report. That's it. I'm going to start asking questions on the report. That's it. He can cross on the report. So as many times as he says.
You notice there's no email like, what is this? What is this bill? We weren't expecting a bill. We're not going to pay this. Nothing like that, right?
I don't know what they're going to testify to. Yes, you do, because they're going to testify to the contents of the report. And those are definitely questions I'm going to ask. So I've got clean hands.
All right, so you're reading from a transcript. As you know, there are dozens of transcripts. What's the volume number? What's the volume number and the page number?
Day 26 of trial, page 248 to 250. I will get a volume number for the court.
That's okay.
This seems to directly contradict the theory that Attorney Alessi has been promoting today of the rules of the road. This does not suggest that ARCA is open for business and private discussion and consultation and payment. It says the opposite. The federal authorities will not allow me to interview or ask for additional information from anybody in their world, so I have nothing. And so this presentation today by Attorney Alessi, suggesting somehow that this was open and notorious, is not backed up by the defense attorneys themselves. The June 10th hearing, we've already been through it. I won't repeat it, but those comments are important. I think what stands out about the prior hearings, and I say that I think that there's a murky.
I think he's talking about Iannetti's statement. Your Honor, I can't give a discovery. You're going to put up 3 witnesses that you've never talked to? I think that's what he's talking about. I can't. There's a federal investigation. Yes, we're putting up 3 witnesses we've never talked to.
Relationship that we have not done more than scratch the surface of is, Your Honor may remember that the defense noticed 3 experts from ARCA, including Mr. Klein. And when we get to June 10th, Your Honor is asking, regarding the 3 experts from ARCA, and this is June 10, 2024, trial transcript 28.
Hold on one second. Let me grab that.
You know, Hank Brennan keeps bringing up the point we haven't scratched the surface. And that's true, we haven't, because they still haven't handed over complete discovery of ARCA. And I think that this is really a dog whistle to the defense. You want to keep going down this road. You want to keep blame shifting and lying essentially to the court. You want to keep going down this road. Let's get full discovery of ARCA in here. It's only going to support my position. You want to keep going down this road? This is the road that you've chose. Blame me for misspeaking what I thought was a fact at the time. I learned differently. That I thought I got the information from the feds and correcting it immediately from a lie that you kept going and money raising on for years. A year, maybe not years. Year plus.
I believe it's page 12.
Months. Okay.
And you were asking about the 3 experts from ARCA. And you mentioned, notably, I can't tell who does what or what the basis of the opinion is. And when you look at the ARCA report, there's no delineation on which of the 3 experts did what in that report. You can't tell what role each of them played from the report. And so if we only had the report, we wouldn't know which of those experts to call. And so when you continue questioning, you were told, you said, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand. And Mr. Yannetti said, that's essentially it. He gives some detail. As mentioned earlier, we've spoken to them only for the purposes of coordinating their testimony and background. The important point for this particular point is that the defense inevitably calls 2 witnesses, Mr. Wolf and Mr. Rentschler. And when they only call Mr. Wolf and Mr. Rentschler, there must be a reason why. Because you can't tell from the report who did what. They noticed 3 experts. So there must be conversations with somebody explaining the witness's role or why only 2 of those 3 witnesses are important for the defense.
Right, because the 3rd witness isn't going to help them out. Let's look at Mr. Klein for a second. This is a good time to do it. So this is the witness they didn't call. Scott Klein. Mr. Klein is a senior accident reconstructionist who specializes in the investigation of all motor vehicle and commercial collisions, particularly heavy truck incidents, including but not limited to commercial vehicle accident reconstruction, imaging, and events data recorders in commercial and passenger vehicles, automotive fraud, and determination of liability. So this is what interests me about that paragraph, the imaging of event data recorders. So would that be her car data that was given in, it was an incomplete download led by the defense? So the defense expert downloaded the material and we only got a partial download of her vehicle car data last time? Would he demanded more of her vehicle downloads? Or did he use more? Why wasn't he used? Mr. Klein is certified by the blah, 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 all these different, in addition to earning his bachelor degree in mechanical engineering from Lehigh University and his Master of Business Administration and Finance and Engineering from Drexel. Mr. Klein is a nationally certified firefighter. Okay. So that gives a little idea that he was not called. Scott K. Klein for ARCA.
And so it is clear from the absence of information, there are much more communications.
Yeah, my point was, Barbie, thank you for bringing that up. ARCA never looked at the data. So would have Scott Klein demanded the data? Would that have been something that they were worried that the Commonwealth would have asked him about, since that's his area? Expertise?
They're
Curious?
expected to be in existence that have not been provided. On page, on June 18th, 2024, the voir dire hearing. The court asks, well, I thought.
What page? I've got the transcript. What page are you on? Do you know?
No, but I
If it's just your notes, that's okay.
can pull it up.
My apologies to your eardrums. I had to move the sound way up because it was very low. Alessi tends to scream into the mic. So when it came time for Hank Brennan to talk, the volume was way low. So when the judge comes in, it's like, woo.
Page 4, line 11, the court asks, so the understanding of the voir dire is that this is for the Commonwealth's motion to exclude this testimony. All right, that's what we're here for, the Rule 14 violation. And Mr. Jackson says, is that the same with Dr. Wolf and Dr. Rentschler? And the court says, well, I thought that would help both of you. The Commonwealth has nothing on that, and you say you haven't been able to even talk to them at all about this case. And the answer is that's correct.
So here's another time they presented to the court that they hadn't talked to them. How many lies is Hank Brennan going to catch them in? How many? I mean, it would have been better if Alessi said, you caught us dead to rights. What can we do to remedy this? Here's everything. But they can't. They need this lie to continue their innocence fraud campaign. Absurd.
Now, refraining from my opinion and characterizations, unlike the defense, I think that the transcript speaks for itself. I'll let it speak for itself. When we continue in the voir dire hearing, page 71.
Okay.
Line 4, importantly, were you hired by the defense in this case? No, sir. Before this morning, when you walked into court, have you and I ever met face to face? No, sir. Now, this illustrates an important point. That is technically true. But what impression is that making to the court and to the Commonwealth? Is that a genuine impression consistent with reality? Line 20, the person.
So he's basically pulling out all their arguments. Well, we hadn't met up to then. He's saying that's not why you said it. The impression was that you're wholly independent, because those were the questions that came afterward. You're a wholly independent entity, right? And you're not being paid, which is like the cherry on the top. Most important fact. All these expert witnesses, the First thing they're always asked, you always can expect in trial, how much were you paid in this case? How much do you expect to be paid? As you sit here, what are you billing for your time? Because that shows to the jury bias. Even though they were represented as independent, unbiased witnesses, unpaid witnesses, the jurors, some jurors, and boy, did Turtle Boy have a good laugh about it, that they stopped laughing now with Ronnie, the EMT driver. Boy, those jurors were really out of their mind to think that they were biased witnesses, paid witnesses, that someone was paying them. Because they were right on the money, those jurors.
To my left, the female to my left sitting here, have you ever seen her before? Nope. Do you know who she is? Yes. And so there is direct and indirect commentary, questions, presentations that reinforce.
Yeah, so funny, Bunny. So in reality, expert witnesses are allowed to talk to the prosecution and the defense. But in this case, the prosecution, Commonwealth, believed that they were barred by a federal investigation from talking to them. So they couldn't reach out. So it's a little bit different here. But you're right. Normally they could have. And the defense even went further, that the prosecution could have used, this is what Alan Jackson said at trial. He told the jury that the Commonwealth could have used ARCA as their witnesses, could have called them as their witnesses, but didn't, because it didn't fit their narrative. I mean, everything about that federal investigation is suspect. It was just a maneuver to scare the Commonwealth and get the charges dropped before trial. When it didn't work, they brought them into trial as unpaid, unbiased witnesses, just lied to the court.
That the defense and ARCA are wholly independent from each other. This is also consistent with the representations regarding payment. There are questions for dare in a trial about whether or not the witnesses were ever paid. It may be technically true they were not paid at the time they were asked the questions, but if there is an expectation of payment, it is a promise, reward, and inducement. It can show bias. There's nothing wrong with.
So this is the argument of the free Karen readers. They're saying there was no promise of payment. That the defense was totally surprised when they got the bill. But so the law has already covered this loophole. Well, when you said that, you hadn't been paid yet. We hadn't gotten the bill. Hank Brennan covered that. Smart to cover that.
Paying an expert. There's nothing wrong with going over a direct examination with an expert. There is nothing wrong with talking about particular questions with an expert. But when these experts are being portrayed a certain way, that they're independent, that there is no evidence or information about them, then it is not a fair representation. It is not an honest representation. Now, it wasn't until Your Honor asked today that we even knew that the defense paid this bill. When you look at the bill, there's some things that stand out. There's a tax ID number, an invoice date of July 12, 2024. It's addressed to...
Hold on one second, please. Okay.
It's addressed to...
Yeah, I got it right. They lied to everyone. Attorney Jackson. And the position that the defense takes
Attorney Alessi takes today is this came out of the blue that they had to pay. Apparently, everybody in the know knew the defense was paying for this expert other than the defense. ARCA experts knew. Dr. Wolf knew. Dr. Rentschler apparently knew. The federal government knew. When you look at the bill, there are things that stand out that are so notable that you can't go back and try to twist them or change them. Look at the first entry of May 1st, 2024. That is before June 10th. That is before the representations that there was no intention of compensation. Apparently, the witnesses they were going to call expected that they were going to be paid by the defense, or they wouldn't have been keeping track of their time back on May 1st, 2024, participated in a telephone call with Alan Jackson.
Right. So they're billing for, they're already keeping record of their time for the bill in May. So they just did that independently, assuming they were going to get paid a certain figure. They aren't fools. All this was ironed out before May.
And so the March 20th email asking for an engagement letter and a retainer. And then the 24th saying we need to take a step back because of the U.S. Attorney's Office.
22nd, I think.
Sorry, 22nd and 24th. There is obviously more communications because the relationship re-engages at least on or before May 1st, 2024. And these witnesses understand that they're going to be paid by the defense. And as I mentioned in the materials we got from the United States Attorney's Office on February 12th, there is no billing related to prep for voir dire, travel, trial, none. So the only people who were surprised that they were paying the witnesses apparently was the defense themselves.
And isn't that ridiculous to believe? I'm going to take a quick break. I have to let out my cat. Does your cat get like that? People who have cats, doors closed, he's freaking out. So I got to let him out. I'll be back in a minute. Don't go anywhere.
We don't take a break. Grab a snack or maybe a glass of wine. Roberta will be back in no time. This podcast is listener supported, so smash that like button and subscribe or become a patron for exclusive content if you are so inclined. Have something to say? Shoot Roberta a super chat. She will do her best to read it all air without delay. Now Roberta's back and ready to put the true back in true crime. Here's Roberta.
Okay, I'm back. Cat is under control. Okay.
And then before that June 10th hearing where the representations were made, there was a June 9, 2024 phone call. Another participated in telephone call with Alan. And then we see before the voir dire testimony, there is billing to the defense, which is now we know paid by the defense, prepared for voir dire testimony, June 17, 2024. What we don't know is, in the preparation, was there any conversation with the defense? Was there any emails? Were there any documents? Were there any outlines? Was there any discussion about their potential testimony, or is this solely the preparation of Dr. Rentschler on his own? On the same date, 3 hours billed by Dr. Wolf, prepared for testimony and hearing. Now, they felt inclined and comfortable billing the defense for. Was there any interaction or discussion between the parties? We don't know. This was the time that the court gave the defense an opportunity to bring in their product, their receipts, the emails, to elucidate illustrate, demonstrate, prove what the relationship was, we don't have anything. We have nothing more than we did last week. On June 18, 2024, a round trip to Norfolk Superior Court by Dr. Rentschler, and also separately for his testimony, 8 hours billed, 12 hours for Dr. Wolf billed to the defense. June 21st, Dr. Rentschler prepares for his trial testimony, bills the defense, 5 hours. Again, we have no idea if that includes in any way correspondence, communication, interaction with the defense. June 21st, Dr. Wolf, the same, prepares for trial, 6 hours. June 23rd, Dr. Wolf travels to Boston for trial, significant delays, and then Dr. Rentschler on the 24th, round trip, Norfolk Superior Court, 11 hours, 6.5 hours respectively, billed to the defense. Now, it's hard to believe these witnesses would put forward money and expenses and travel without some understanding that they were going to get paid.
Right. So as they're sitting on the plane, they're getting paid. You heard him say significant delays. The plane was delayed. They're getting paid every hour for that delay. Every hour the plane is delayed, every minute it's delayed, they're getting paid. They're on the defense's dime.
It is hard to believe this company, especially after receiving an email about engagement and retainer, especially after having conversations, collaborating on their potential testimony. It is hard to believe that they would come to Boston, spend their time and their own money to do this, to just simply send a bill later with no expectation of being paid. In fact, it's a very specific accounting of their time. And when one accounts for their time, it's because they need to have a contemporaneous record so they can get paid for that time. Also billing for wait time and travel, testimony at trial on June 24th, and then there's expenses for June 18th and June 24th. Specific expenses, $1,749, $1,932. So they are keeping very careful track for the bill that they send within 1 month of the defense that gets paid that Commonwealth and the court never knows about. Talk about correcting a record. And so this $23,925, we find out today, it was paid by the defense. We hear that there was a conversation with the federal government. We have no affidavit. We have no witness. We have no writing, no email, no correspondence, nothing to support or put in context the conversation. Nothing. Nothing. And so,
Hey, kiddies. 1993 asks if they weren't removed, what other consequences are possible? ARCA could not testify. They could get some other sanction. God knows. I don't know. I'm not. They could also. What else? Hold on 1 second. Getting a buzz in my headphones. What else? They could I think they could get some kind of monetary sanctions from the court. They could be fined, I believe. But you'd have to ask a lawyer how all this would go down. So.
when you look at the story on this bill and the timing of it and the details of it, we know that we are getting a fraction of the story, a fraction. It's not enough to blame the court, blame the Commonwealth, blame the U.S. Attorney's Office. There's some accountability. In addition, when you look at the totality of representations made in court, we also, at some point, are going to address the Commonwealth's position of violations of 3.6, separate motion. It's interesting that after the last court hearing, well-known reporter, very reputable reporter, Christine Rex, asks Mr. Jackson about paying the bill. And what I'd suggest, more 3.6 activity. Quote, no, of course not. That was the position last week. So what we're left with is we still don't know the relationship between the defense and ARCA. We don't know about the impact it had on the first trial. There has been these multiple representations.
I just want to show you exactly what I'm talking about here. So this is Alan Jackson. This is what Hank Brennan just referred to. This is Christina Rex's post. Oh, did my computer just spaz out? Okay, I had it all set up. I just wanted to blow it up for you. Hold on one second. My apologies. Here we go. So,
Alan, what was that about?
No idea. No, she didn't say.
Did you pay the ARCA experts to testify in the first trial?
No, of course not. No.
Alan, what was that about?
No idea. No, she didn't say.
Did you pay the ARCA experts to testify in the first trial?
No, of course not. No.
Alan, what?
okay, of course not. Of course not. Of course not.
That ARCA was independent. They had their opinions and they were exculpatory. ARCA's opinions changed. There were 4 opinions. And if you look at the report, and I'm not going to read it for the sake of the press and the public, we'll have a trial and we'll vet it at trial. But when you read the report, clearly the representations made about that report were extended at trial. And the question's going to be, why? Why did they improve? Why did the
Particular page you'd like me to look at without.
And this is what Hank Brennan's been asking about all the experts. We've had Marie Russell, Richard Green, ARCA experts, all their conclusions all seem to develop after talking to the defense and change. And with Alessi on board, there's huge differences, Hank Brennan has noticed, between the language used in their conclusion. We know Marie Russell said Alessi helped her with her report. And then she put her foot in her mouth and said, oh, no, it was just to put which boxes go in which areas. She didn't know how to arrange her report. Give me a break. When her conclusions language all changed drastically, when Alessi voir dired her and Richard Green, same thing. So this is what Hank Brennan's up against.
If you look at the first page,
Yes.
if I can have a moment.
You don't have to read any of it. You just tell me what paragraph.
Yeah, I believe it's just the first paragraph that lays out their findings.
Thank you very much.
I'd actually particularly note number 4, and both publicly, repetitively, but also at trial, the parameters of that were extended substantially. There is a summary again at the end of that report, substantially says the same thing. If you look at the last page,
Okay.
which is signed by all 3 of the experts, Mr. Wolf, Mr. Rentschler, and Mr. Klein. says essentially the same thing. So we would be oblivious if we stood here and said that the relationship between the defense and the experts, there is no relevance to bias or motive or desire to please, because clearly there's a change, there's an expectation of payment, there's communication, and to suggest that an outline was provided so close to the testimony, therefore it shouldn't have been shared. It isn't just what's in that outline. It's the fact that they have the relationship. Attorney Jackson may have brought out that accidents happen often at night. It's not the point. The point that the ARCA witness is willing to forego that information as a benefit to the defense. That is the heart of what is missing and what is hidden. And so there are a number of instances, 3 of them, in the outline where the ARCA clearly is trying to accommodate the defense. And by representing to the court that there is no relationship, the hands are clean, they have no information, is not only not accurate, it is misleading and unfair. So we know there is more.
Right. He's saying this is the tip of the iceberg. It's not just misleading, it's unfair. And this is why I say the judge has been called out. Because she let all this go on. Oh, a voir dire. He's like, voir dire, that doesn't help us. We don't know the questions to ask after a short voir dire. Doesn't get to the heart of the matter. Especially when they're lying to the court and saying they're not getting paid, they have no relationship, etc. We can't ask about biases if we don't know there's one going on. We don't know there is a bias. I mean, if you look at Lally's questions, they obviously suspected. Why didn't you ask for any information from the defense, from the Commonwealth, excuse me? Why didn't you want the complete record? Remember when the ARCA, I can't remember which one, testified that it wouldn't make any difference having all the information instead of some information with his conclusions. That's absurd.
The question is, will we get it before trial? I have another TUI letter going out this week. I don't know how long it will take to respond to it. And the TUI letter is not going to be thorough and complete. It's just not the way TUI works. And so we are in the same spot. Well, actually, we're in a better spot. We know now about the relationship. We know about the potential bias. We know about the payments, but we don't know the full scope of it. And so we are entitled to that information. We don't know what conversations or communications the defense had with the ARCA experts that the federal government doesn't know about. Over the next few weeks, we're going to attempt to get more information, but we will never have an act.
Right. She's the one. Let's just review. This is the judge who moved the entire courtroom on the request of the defense. So are we to assume that, in the over 100 years since this courtroom has existed, and we know that it's existed over 100 years because Sacco and Vanzetti, which is really the first innocence fraud campaign, happened in that courthouse. So are we to assume that, and I believe that courtroom, I may be wrong, but are we to believe that no one who was tried in that courtroom had a fair trial? Or should we overturn every conviction done in that large courtroom because of the sight lines of 2 jurors? Come on. She should have demanded that they hand over all the discovery last trial instead of these nonsense voir dire hearings. All this is why Judge Cannoni is reacting, shaking, etc., because she's been exposed. All this has been done under her nose. And by letting a fraud happen, you're making it happen. In Donna Adelson's case, when Judge Everett, when she tried to move, she got a clue because all these innocence fraud lawyers get ideas from each other. When they wanted to move the courtroom to a smaller courtroom in Donna Adelson's case, he was like, no way. Can't do it. Sorry. No. Instead, she's rubber stamping one ridiculous thing after the next.
Accurate accounting, unless it's compelled. Your Honor has mentioned the sidebar,
Which one?
the most recent one.
Okay.
I am not trying to be overly critical of another attorney. I'm not. You can laugh, but I'm not. It has been.
That was to Karen Reed was apparently laughing at that. You can laugh, but I'm not.
My effort to get Rule 14 material. It has been my effort not to exclude ARCA witnesses. It has been my effort to try to achieve fair play. There's been no other way to compel any information other than to file motions in this case. And it is not incumbent on the government to fight for this information. We're entitled to it. We're entitled to it. And at this point, we have no confidence whatsoever, none, that we're going to receive the information that we deserve.
So essentially he's saying we've just touched the tip of the iceberg with what we've gotten, and we have no confidence that we'll get what we need in this case. Therefore, exclude the ARCA witnesses, and they may be excluded. We'll see. Jackson may be thrown off. Yannetti may be thrown off. Very bad couple weeks for Karen Reed's defense.
All right. Thank you. Mr. Alessi, very briefly, if you have something.
Yes, thank you, Your Honor. I'll be very brief. The experts keep track of time. They had historically been paid by the government. There's another completely rational, more probable explanation.
Right. They were keeping track of their time on the plane flying to Canton because they thought they were going to be paid by the government to testify in Karen Reed's trial. This is the kind of ridiculous arguments Alessi comes up with. I'll just give you a taste, a tiny taste of it before I go.
That they had been retained by the government. They were being paid by the government. They maybe at a certain point didn't know who was going to pay their bills because they turned out they were going to provide him testimony. That is a whole different issue, what they expected to be paid and by whom from what the defense expected. So two things can be true. It can be at some point they thought they were going to get paid, but up to that.
And you see how he yells? Invincible says, hey, Roberta, Karen Reed is even in more trouble in the recent ID trailer. She said Jen McCabe invited them to the Albert's house. She said, Hank Brennan will do very well. I hope so. She said Jen McCabe invited them to the Albert's home.
At that point, they were being paid by the government. And in the entries, all that Mr. Brennan went through, particularly the early.
Are you saying that that's not good for Karen Reed because there's another interview where she says, I don't know if we're welcome here, who invited us? Is that what you mean, Invincible? Thanks so much.
There is zero evidence before the court on any basis that they expected on those dates of those entries that they were going to be paid by the defense. And it's very important because Attorney Brennan spent most of his time on that invoice. With regard to the comment he made, and this is the problem when we don't have notice, like I provided a notebook so everybody could see it. We don't have some of the things that Mr. Brennan was referring to, but he referred to, of all things, Mr. Jackson's response to a reporter. We're here talking about communications to the court.
Right. We all know that you can lie to the reporter. We all know you can lie to the reporter. Often innocence fraud technique used. That's why Karen Reed's been giving so many interviews. It's not illegal to lie. Why she won't testify under oath? It's not illegal to lie to a reporter. We all know that. But it certainly doesn't follow the standards of good practice for an attorney, and to misstate fact to a reporter about a case that you're doing. I think the California bar should be notified of that. Don't you, Mr. Alessi? Don't you want these fraudulent lawyers out of your profession? Why are you protecting them? Why are you lying for them?
But to be clear, the reporter asked, did you pay for testimony? Did you pay for testimony? Mr. Jackson, of course, said, no, I paid for their time.
No, he didn't. No, he didn't. No, he didn't. That's a lie. Didn't say anything of the sort. We all saw the interview. We just watched it.
Did he say I paid for their time?
Pardon me?
Did he say I paid for their time?
Mr. Jackson?
I said the words, of course not.
Okay.
Did you pay these witnesses for their testimony? And I said, of course not. If the court were to ask me that question today, I would respond exactly the same way.
All right. So you
Liar, liar, liar. This is my opinion.
You just told I paid for their time. That was not said, right?
That was not said, but I'm saying
that's what I
there's
just
always
asked.
some inference.
Right. She was ready to buy that hook, line, and sink. I just can't. I think this is a good place to leave it. I mean, that'll just give you an idea of the lying, ridiculous arguments that they make. I'll be back Saturday. Hopefully I can get rid of whatever this is I have. By Saturday, I'm going to be talking about Donna Adelson in her hearing. Thanks to everyone who watched that on Saturday. Crazy hearing, lot to talk about. Don't miss it, 6:00. And we'll be back to Karen Reed probably, I don't know, Sunday or Monday. That's what I at least have envisioned now. Have a great night, everyone. Thanks for listening. See you Saturday.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mom. My innocence fraud campaign is my biggest hit yet. I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mom. innocence fraud campaign is my biggest hit yet.